Welcome to ELI's session on climate change and environmental law of summer school. So excited to see you here in person and online. This is our second to last session of summer school that will be held in person at ELI's office, but we still have 3 more that will be streamed online only, and then 1 more that will be virtual or that will be in person. We have to just announce a new session of summer school disaster and mitigation law. So registration is not yet open, but it will be within the next few days. So be sure to sign up for that. Our speaker slides today will be posted on the event webpage. So if you are online, we'll put the link to that in the chat. If you're in the room, when you get home, be sure to check them out there. This program will be recorded and posted on ELI's website and YouTube page for everyone to check out later. So if you miss any portions of it, be sure to look at that. And now I will go ahead and hand things over to today's wonderful moderator. But a huge thank you to everyone for being here, to all of our wonderful speakers for coming out in person. We so appreciate it. And moderating today is Helene Krasnoff, who is a senior attorney here at ELI. And she's also the director of the Climate Judiciary Project. She's responsible for the leadership, strategy, and management of CJP, which has brought evidence-based education about the science of climate change and how it is arising in the law to thousands of judges. Prior to joining ELI in January of 2024, Helene spent more than 20 years at Planned Parenthood Federation of America, where she litigated and supervised dozens of high-profile cases in all levels of both federal and state courts. So Helene, I'll hand things over to you. Thank you so much.
Thank you. I'm excited to be joined today by this esteemed panel. I'm going to give you a rundown of who they are and what to expect for the next couple hours, and then turn it over. So first, we're going to hear actually an introduction to climate science from Dr. Marisa Borreggine. It's helpful to have some grounding in the science to understand why are we passing these laws, what is happening. Dr. Borreggine is an Institute Associate in the Adaptation program at the Georgetown Climate Center. They earned their PhD in Earth and Planetary Sciences and Archaeology from Harvard University, and her work focuses on policy analysis to help local, state, and federal governments address impact from the changing climate. Next up, we will have Upasana Khatri, who is a senior attorney with the Climate and Energy Program at the Center for International Environmental Law. And she is going to focus on the international landscape. Her work focuses on protecting human rights in the context of the climate crisis by developing and supporting legal and advocacy strategies related to climate litigation and accountability and accelerating the transition away from fossil fuels. She's also an adjunct professor of law at George Washington University Law School, where she teaches a course on human rights and the environment. After we look across the world, the next 2 speakers are going to focus on federal law here in the United States. First up will be John Cruden. John is a principal at Beveridge and Diamond and an adjunct professor at George Washington University teaching environmental law. And he is the past president of ELI, also the past president of the American College of Environmental Lawyers, and the past chair of the American Bar Association section on the environment, energy, and resources. And then we will hear from Jeffrey Holmstead about what changes are being made or expected to be made to federal law by the current administration. Jeff is a partner at Bracewell, LLP, and heads the firm's Environmental Strategies Group. From 1989 to 93, he served as the White House counsel's office under President George H.W. Bush, where he was involved in the development and implementation of the 1990 amendments to the Clean Air Act and the United Nations Framework Convention on Climate Change. In the George W. Bush administration, he served as the Assistant Administrator for EPA for Air and Radiation, a position he held, I don't know if this is an honor or not an honor, right? He held longer than anyone in the agency's history. That's really great.
It means I'm a glutton for punishment.
And then finally, I'm going to provide a very brief overview of some of the state's responses to climate change and how these issues are arising in the courts. So thanks again for being here. Thank you all for joining us. And I'm going to turn it over to Dr. Borreggine.
All right, here we are. Well, thanks so much for being here today. And thank you again to the Environmental Law Institute for having me. Like Helene said, I'm going to start us off with an introduction to the climate science. My friends at ELI love to ask me to give a semester's worth of climate science in 20 minutes. So by the end of this, you guys are all going to have a degree from Harvard. It's going to be great. So our outline for today is we're going to give a brief introduction to GCC, the Georgetown Climate Center. We're going to talk about Earth's energy balance. Then we're going to talk about climate risk. We'll talk a little bit about sea level rise because that's my specialty. So I like to talk about sea level rise, and then we're going to talk about mitigation and adaptation. So to get us started on our introduction, first, I like to talk about what the Georgetown Climate Center is and what we do. There are 4 things that we like to say that we do that is somewhat different from comparable climate policy centers. First of all, we are really the only center that's working at that crucial intersection of local, state, and federal climate policy. We also were established at the behest of leading states, so we do have a special relationship with state governments. We also like to apply our expertise on both ends of the climate policy equation, so both to reducing pollution through climate mitigation and also through adapting to climate change impacts through climate adaptation. And finally, we don't think of ourselves as a think tank. Our ideas are really only as good as they are applicable. So we focus a lot on partnering with federal, state, and local leaders to make sure our ideas get out into the world. Now, the 2 programs that we have at the Georgetown Climate Center are both climate adaptation and climate mitigation. We'll talk a little bit more later about what exactly those are, but because I will be using these terms, I want to start us off with a baseline here. Climate adaptation are all the activities that we do to adapt to a changing climate. So think about seawalls and elevating homes and living shorelines, things like that. And mitigation is reducing carbon dioxide emissions and other greenhouse gas emissions. So think about things like solar panels, encouraging public transit, electric cars, things like that. I will also say, confusingly, in climate adaptation, we use the term mitigation to refer to reducing climate hazards. So I will try to not use those terms interchangeably, but that is a confusing thing. My work is in the adaptation section. Like Helene mentioned, I did my PhD in Earth and Planetary Sciences. I focused on sea level change and human migration. So I don't claim to be an expert in all climate science, but I'm happy to help us work through any climate science questions we have. And my background's also in physical oceanography. So I'll talk a little bit about the basics, and then we will talk about sea level change specifically. So why have a climate scientist on our wonderful climate policy panel? Well, because science matters. We know that temperature is rising globally due to human-caused climate change, and what you're seeing here is actually an art installation from Copenhagen. This is called the Copenhagen Bench. There are several of these benches around Copenhagen. They show how high a bench would have to be in the year 2100 in order to avoid getting your feet wet from sea level rise. I believe this is under like an extreme sea level scenario, but still, it does paint quite a picture. And there is consensus around this in the climate science field. Climate change is caused by human beings. We have greenhouse gases increasing in the atmosphere that cause warming and cause climate impacts like sea level rise. And we can reduce our reliance on fossil fuels as a way to mitigate that change. We also have effects on society and the environment that are becoming a lot more common and severe and frequent. So, for example, 600 million people globally live within 10 meters of the shoreline, and that number is growing every year. There are impacts on infrastructure, agriculture, businesses, transportation, public health, and the environment. There's also impacts on environmental justice and on cultural heritage that are really critical. And of course, for our audience, there are also impacts on legal cases. The legal cases involving climate changes are increasing. I know that my co-panelists will be talking about this, but one way that you can get ahead of the needs of the people that you'll be working with and working for is knowing the science. So let's talk about the science. Let's talk about Earth's energy balance. Like I said, climate is increasingly impactful for courts. And if you're a judge, if you're a lawyer, if you're somebody who's working in climate policy, it's pretty likely that you're going to end up having to navigate a complex scientific or technical concept at one point, for example, during fact finding or during research that you're doing for a case. So let's talk about the science and how you can learn a little bit more. This is an incredibly important figure, an incredibly important slide, and is sort of the semester's worth of science on a slide. So we'll try and get through it. But what you're seeing here is a picture of the greenhouse effect. So one thing that's really critical to understand about the climate is that it is fundamentally driven by the sun. It supplies Earth with solar radiation, and some of that radiation, as you can see on the left, is being reflected back to space. And some of that radiation is absorbed by Earth's surface and warms it. When that heating happens, some of the radiation is also emitted back into space. Some of it is reabsorbed by the atmosphere and re-emitted back to Earth. And Those things that are being emitted back to Earth through gases are things like carbon dioxide, methane, and nitrous oxide. And this is pretty similar to how a greenhouse traps heat, hence why these are called greenhouse gases. And the greenhouse effect, not all bad. Without the greenhouse effect, Earth's surface would be so cold it wouldn't be able to support life. But the problem is that since the Industrial Revolution, human activity has increased our use and the concentration of greenhouse gases in the atmosphere, mostly through burning fossil fuels for energy, which is causing the climate to change in some negative ways. And like I said earlier, climate science is unanimous in this finding, and we're confident in it for many reasons. So, oh, went too fast. There we go. One thing that I want you to see is an example of how greenhouse gases regulate temperature globally over millennia. So what you're seeing here is what we call a stack. So this is a stack of atmospheric carbon dioxide over the last 800,000 years on top, and Antarctic temperature on the bottom. Again, also over 800,000 years. These are ice core reconstructions of atmospheric carbon dioxide levels and temperature that show how long greenhouse gases have regulated global temperature. There are also changes in Earth's orbit. You might have heard about Milankovitch cycles before that also are important for regulating Earth's climate on longer timescales, but those are timescales like thousands to tens of thousands of years and can't explain the relatively rapid increase in temperature that we're experiencing over the last century or so. And I'll also note that in geologic history, Earth has certainly been warmer than it is today, but it's really the rate of temperature increase in the post-industrial era that is unprecedented over this interval. One graph I also want to make sure that you see, if you have not seen this before, you will see it so many times in your career if you're doing anything in climate. This is showing the level of atmospheric carbon dioxide from the Mauna Loa Observatory in Hawaii. This is run by Scripps Institute of Oceanography. This shows how human activity, predominantly through the use of fossil fuels, energy and land use and agriculture, has really dramatically increased our concentration of carbon dioxide in the atmosphere. This is the longest observable record of carbon dioxide in the atmosphere going back to 1958. This is a direct observation. And as you can see, carbon dioxide is rapidly increasing in the atmosphere, which is causing temperature to increase as well. So what you're seeing here is a graph of temperature from NASA. This is global temperature going back to the year 1880. And this is the average temperature of the Earth as compared to, well, this is an anomaly of temperature over the Earth as compared to the 1881 to 1910 average. So what this is showing us is that Earth has warmed by about 1.2 degrees Celsius or a little over 2 degrees Fahrenheit on average over this period. But one point I also want to make is it's not just temperature. You know, in the 1990s and earlier, we talked about this as global warming, but there's a reason that we call this climate change now, because all of these effects that you see here, like global precipitation and river runoff and Arctic moistening, things like that, those are connected to temperature because all climate systems are connected. They talk to one another. But there are many other climate impacts beyond temperature that are also important. And these also represent the many venues through which climate impacts can show up in your work as a legal professional. For example, increased precipitation and sea level rise are things that can cause more flooding and inundation. That's going to impact property law and zoning. There's also sea ice issues that can get into maritime law. It can get international very quickly. So why should anybody really care about an increase in global mean surface temperature? It's because increasing temperature and increasing climate impacts lead to risk in human and natural systems. What you're seeing here is a simplified version of the Intergovernmental Panel on Climate Change's risk wheel. What this tells us is that our risk is a function of our vulnerability, our exposure, and our hazards that we face. And risk varies under different warming scenarios, but what we do know is that the more warming there is, the more risk there is. And these impacts, I should say, are not distributed equally across race, across age, across geography, health, economic status. And we talk a lot about global trends whenever we think about climate change, but what matters to everyday people, to clients, to lawyers, to people in climate science as well, is often what is happening locally. And certain communities, especially those who may have not contributed the most to the global budget of greenhouse gases are usually bearing a disproportionate brunt of these climate impacts. So think small rural communities, island nations, underserved groups nationwide. And this is true for all of the modern perils that we face: drought, heat, wildfire, and sea level rise. So let's talk about sea level rise. Indulge me, I'm a sea level rise scientist. This is one of many climate risks, but I think this is a good example that demonstrates how we can think about global to regional climate impacts. So to start, I like to talk about how we define sea level rise, because I was just talking to one of my colleagues and he was like, I don't get it. Like, there's so many definitions. There's sea surface height, there's sea level pressure, there are all these things. So I should say the way that a lot of people approach sea level rise in general is through something that in the field we call the bathtub model. And this idea is that if you have a bunch of ice melting uniformly across the globe, we have sea level going up. If you have a bunch of ice growing, if it's an ice age, uniformly you have sea level going down. But it's actually more complicated than that, because Earth is not a bathtub. The first paper I ever wrote was called Earth is not a bathtub, but look it up. And in fact, sea level is geographically variable. The distance between the sea surface and the ocean floor is actually how we define sea level change, or sea level rather. And you can get a change in sea level from changes in either of those boundaries. So either the sea surface is going up and down, or the ocean floor is going up and down. So let's look at an example of that. Let's say you have a bunch of ice melting, and now you're going to have sea level change. You have a new sea surface, you have a new sea level has changed, and you have a new shoreline. And that area that's shaded here, now all of that is underwater. So if you have a house on the shoreline, now that's underwater. That's where we start getting into property law. And it's important to think about how sea level is defined locally, because there are a lot of processes that control sea level globally, but what matters is what's happening locally, because it can depart a lot from the global average. So let's look at that a little bit more in depth. For example, what causes sea level to change regionally? Here are some of the major processes. We have ice melting, which can cause land to go up and down as it's loaded and unloaded. We have ocean dynamics, and we have density changes. There's ocean atmosphere interactions. You can also have groundwater storage that can change sea level. And these are important on like shorter timescales. On geologic timescales, things like continental drift and plate tectonics, those also have impacts, but those are like million-year scales. Human timescales, like 10,000 years or less, these are some really important processes. So just to check our understanding, what do we think is the most important for sea level today? Raise your hand if you think it's vertical land motion. Okay, what about ice melting? I see some very gentle hands. It's okay. This is a safe space. And what about thermal expansion? Okay, so this is the answer I would expect, because yes, ice melting is by and large the most important, and then close second is thermal expansion. Those are the two most important factors for sea level change today globally. But these processes regionally can change what sea level looks like. So for example, in the Pacific Northwest in Alaska, sea level is actually falling because you have land uplifting faster than sea level is rising. In the Northeast and in the Gulf Coast, sea level is rising a lot faster than the global average because of local ocean dynamics. So those things are important to understand if you are working in those regions. Let's get back on track here. So I also want to talk about how we think about climate processes in general. This is for sea level change, but it really is broadly applicable to observing climate phenomena. So this graph is showing estimates of the past of sea level change, our instrumental record for today, and also projections of the future. So when we're talking about past climate phenomena, we are estimating those things. We're using proxies to figure out what those are, like the ice cores we looked at earlier. When we're talking about sea level change today during the instrumental record, the instrumental record varies for the phenomena we're observing, but we are observing. So here we're estimating, here we are observing. And then going forward into the future, we are modeling, we are projecting. And there's a level of uncertainty that's associated with all of these things. So when we are estimating things in the past, it's difficult to convert from a proxy like an isotope from an ice core directly into temperature or to sea level. So that's where that uncertainty comes from. Uncertainty in the instrumental records just comes from how good our instruments are. And as you can see, as we move forward closer to today, our instruments get better, so the uncertainty gets smaller. But moving forward into the future, there's also a relatively large amount of uncertainty, especially as you go farther into the future. And that comes from not only questions about what the climate will do, but what people will do, how much greenhouse gas will emit. And I think that's important to talk about because since the 60s, we know that the rate of sea level rise has been accelerating, and that's ongoing today, it's ongoing into the future. And reducing our greenhouse gas usage will stabilize that, but we are locked into a degree of rise no matter what. So what does that mean? It means that future extreme events because of sea level change and other climate risks are going to increase. They'll become more intense, more costly, and more frequent. But there are ways that we can deal with that. There is cause for hope. And that's what I work on now at the Georgetown Climate Center in mitigation and adaptation. It's important to end on a hopeful note. So climate mitigation, what is it? We talked about it earlier. It is these activities that help reduce climate change. So these are things that reduce our sources of gases, so reducing our reliance on fossil fuels, for example, and enhance our sinks, so the things that take up carbon dioxide from the atmosphere. So that's things like planting forests. And mitigation can be kind of difficult. It can be a big ask. It gets into global politics pretty quickly. What we're seeing here is a graph of greenhouse gas emissions by the US and other sources. On the left, it's annual. On the right, it's the total sum over time, going back to the start of the Industrial Revolution. And as you can see, these values are increasing with time. There are also ways that we can look at emissions by sector, and the wedges that you're seeing here, those different colors are different sectors, and the bold line at the closer to the top is the total emissions. This is a combination of all United States emissions plus our negative emissions from our sinks. So at the bottom, you can see that sort of dark teal. Those are things like planting trees that take up carbon. The dashed line moving forward is the path that we would have to be on in order to hit net zero carbon emissions by 2050. So as you can see, some impacts are already locked in, but this is why we need climate adaptation in addition to climate mitigation. What is climate adaptation? Well, these are actions that help reduce our vulnerability to climate change, like the risks that come with sea level rise, biodiversity loss, flooding, hurricanes, things like that. And those methods are usually infrastructure, natural solutions, like nature-based solutions, and hopefully they are proactive behavior and policy changes. So the thing I want you to remember about adaptation, it's actionable, it is proactive, and it reduces risk. And because I am on the adaptation team, I'll quickly say what our approach to adaptation is at the Georgetown Climate Center. We take a four-pronged approach. First of all, we focus on making sure that when relocation happens or managed retreat, whatever term you prefer, that it's happening safely, it's happening with dignity, and also that any hazardous development that might happen, we can try and discourage it. We also hope to foster better governance structures that prioritize resilience. Also right now, because we know that resilience funding is really under threat, that making the most of every resilience dollar is critically important. And we also want to shape the public conversation around resilience and adaptation in a time where it really is more critical than ever, and that climate adaptation can really mean life or death. Now, I briefly want to end with what some US climate adaptation efforts are. There is previously the National Climate Assessment. The fifth one came out a couple of years ago. This is the US government's preeminent report on climate change. It's congressionally mandated and coordinated by the US Global Change Research Program, a conglomerate of 15 scientific agencies. It is policy neutral, but policy relevant, and it evaluates current and future major trends in climate change. Some of us probably know the status of the 6th National Climate Assessment is really uncertain as the US Global Change Research Program is under attack, but thankfully, the American Geophysical Union has decided to take up trying to publish their own 6th National Climate Assessment. So hopefully we'll see that on a relatively similar timeline. There is also NOAA, the National Oceanic and Atmospheric Administration. They put out adaptation science, and they also have adaptation science partnerships. They're also being cut and laid off and impacted by the current administration. And of course, I have to mention FEMA. I used to work at FEMA in the Hazard Mitigation Assistance Program. Those are our grants like the Hazard Mitigation Grant Program, Building Resilient Infrastructure in Communities, or BRIC, the Public Assistance Mitigation section, as well as flood mitigation assistance. And many of those programs are being cut or stalled. So one thing that we are really seeing at the Georgetown Climate Center is that the responsibility for both adaptation and mitigation is being shifted from the federal level down to the state and local level. And we're trying to help our partners navigate that shift right now. So finally, we'll end with some key takeaways. First of all, on the point of greenhouse gases, the level of greenhouse gases that trap heat in our atmosphere mostly come from human activity, and they are really the most important factor in determining what our risks will look like today and moving forward. Also, we talked about sea level rise and the fact that its impacts are becoming increasingly risky for coastal communities, but that you can apply the thinking about global versus regional sea level rise to other climate impacts as well. And finally, climate mitigation and adaptation must both happen together in order to help reduce the risks that we're seeing from modern perils, such as flooding, heat, drought, wildfire, and more. That is all, and I will pass it to my colleague. Thank you so much. I look forward to taking questions later.
So that's a hard presentation to follow, but I actually really appreciate it because it really underlines the urgency with which governments need to act to address climate change and why we're seeing, rising tide of climate litigation, as well as efforts at the international level to hold states accountable. And as someone that works in international law, when I refer to states, I mean government. So throughout my presentation, that's what I'm talking about. So I have 20 minutes to go over the international legal landscape, which is not possible. So I decided to focus my presentation on a particularly timely pathway that we're currently seeing, and that is the international climate advisory opinion processes that are currently proceeding before 4 different international tribunals. Just by a show of hands, has anyone heard of the climate advisory opinions in this room before? Just a couple of hands up. Yeah, some more folks. Great. So for those that aren't familiar, I hope I can provide a brief overview of what they are, what they mean for climate justice, and what we expect to see in the upcoming decisions that are coming as soon as Thursday, which I'll talk about shortly. And these advisory opinions, or AOs, which I'll refer to them as, really could provide critical guidance to states and courts, shape future climate litigation, inform regional and cross-regional initiatives, as well as national level policies. The AOs are also expected to critically contribute to climate negotiations, which so far have failed to result in the level of ambition that we need if we are able to, or if we're able to avert the worst possible impacts of climate change. So what exactly are advisory opinions? To put it simply, they are judicial opinions that constitute authoritative statements of binding international law. Rather than addressing a dispute between parties, advisory opinions entail interpretations of law in response to specific questions, sometimes in relation to the interpretation of specific treaties and legal instruments over which a tribunal might have sort of authority to interpret, or they might be in relation to broader areas of law, including customary international law. And as we'll discuss, who exactly can request an advisory opinion from these courts will vary by the court, whether that's a state party to a treaty or a forum, a multilateral organization like the UN, or civil society. And I want to emphasize that while some advisory opinions might not have inherently binding legal force by themselves unless explicitly stated, they nevertheless can carry substantial legal weight. As the ICJ, the International Court of Justice, has recognized, AOs are instruments of preventive diplomacy. In other words, diplomatic action taken to prevent disputes before they escalate to full-blown conflicts between states. And so for my presentation, I'll focus specifically on the climate advisory opinion processes of 4 different international courts. 3 of these proceedings, those before the ICJ, the Inter-American Court of Human Rights, and the African Court of Human and People's Rights, are currently pending. And then a 4th, that of the International Tribunal for the Law of the Sea, concluded last year in May. For each of these proceedings, I'll provide an overview of the questions before the respective tribunals, and some of the key expectations and takeaways that have come out so far. I'll also discuss how these AOs have the potential to set the stage for climate action, accountability, and justice. I think I went too far. Okay. So as mentioned, the first international climate AO to conclude was that before it lost the International Tribunal for the Law of the Sea, which is an independent judicial body that was established to adjudicate disputes arising out of the interpretation and application of the UN Convention on the Law of the Sea. This AO process was initiated in 2022 by the Commission of Small Island States on Climate Change and International Law, or COSIS, which is a coalition of small island developing states who, despite contributing the least to anthropogenic greenhouse gas emissions, are among those most vulnerable to climate impacts. In its request, COSIS asked ITLOS to clarify two things principally. One, the obligations of state parties, the obligation of state parties to UNCLOS to prevent, reduce, and control anthropogenic greenhouse gas emissions as the primary driver of climate change, ocean acidification, and related harms to the environment. And two, the obligation of state parties to affirmatively protect and preserve the marine environment from such harms. The AO process drew unprecedented participation of more than 50 states, international organizations, and civil society organizations, including CIEL, who weighed in through written submissions as well as oral interventions. The process culminated in an AO that was issued in May 2024, and I'll go over the highlights shortly. So the next AO proceeding to be officially launched was before the Inter-American Court of Human Rights. That's an autonomous judicial institution whose purpose is the application and interpretation of the American Convention on Human Rights. This climate AO was initiated by the governments of Colombia and Chile, who in their request acknowledged the human rights, specifically the human rights effects of the climate emergency, highlighting the specific vulnerability of communities and ecosystems in Latin America and the Caribbean. Notably, Colombia and Chile emphasized the need for regional standards to accelerate to confront climate change. And to note, prior to this proceeding, the Inter-American Court had already issued 30 previous advisory opinions that have had a lot of legal weight and influence jurisdiction within the court as well as within the region. And this includes one advisory opinion from 2017, which recognized the right to a healthy environment as a fundamental human right, as well as affirmed states' responsibility for cross-border environmental harm. And it's also worth noting that out of all of the climate advisory opinion processes currently proceeding, the one before the Inter-American Court has probably the most extensive questions out of all of them. And this includes questions related to adaptation, mitigation, remediation of loss and damage due to climate harm, the protection of environmental defenders, the rights of future generations, and the relevance of the principle of common but differentiated responsibilities and respective capabilities in defining states' obligations. The extensive scope was reflected by unprecedented participation, with over 160 delegations delivering arguments before the hearings, which happened last year, and with the submission of more than 260 amicus briefs. And it's important to note that unlike the ICJ and ITLOS, the Inter-American Court actually included in its official record interventions from civil society organizations, including dozens of Indigenous and Afro-descendant peoples, as well as communities in the Americas that are on the front lines of the climate impacts. Next, we have the currently pending advisory opinion before the International Court of Justice, which is the principal organ of the UN and the world's highest court. Under the UN Charter, the UN General Assembly has the authority to request an advisory opinion through the passage of a resolution. And just to note that in the case of the climate AO, the 2023 resolution was adopted unanimously. And I want to highlight that even though the resolution was officially launched through the passage, the ICJ proceeding was officially launched through the passage of the resolution, it was really the process was the result of relentless efforts by Pacific Island students, other Pacific leaders and organizations, global campaigners, and the leadership of many states that are on the front lines of the climate emergency, including the Republic of Vanuatu. And essentially, there are two defining questions before the ICJ. They are, what are states' legal obligations to address climate change? And what are the legal consequences if states fail to meet them? And in presenting their take on these questions, 96 different states from every region of the world, as well as 11 international organizations, participated during the oral proceedings last December, which lasted a few weeks. And these interventions really revealed key issues of international law that hopefully the court will address through its advisory opinion this summer, which may come as soon as July, or at least within the next couple of months. Finally, last but not least, and I keep on, okay, there we go. The most recent AO process to be initiated was just happened a few months ago before the African Court on Human and People's Rights. This court is a continental court established by African states in order to ensure the protection of human and people's rights in Africa. And it basically complements the functions of the African Commission on Human and People's Rights. And what's interesting about this AO process is that unlike all of the others, this proceeding was actually launched not by states, but by civil society organizations. And they called on the court to affirm that African states have an obligation to protect their populations from climate-related harms and to ensure that human rights are safeguarded in all climate action. And in their petition, the civil society organizations asked the court to clarify the following issues: the legal standards for climate mitigation, adaptation, and resilience, as well as the redress of loss and damage, legal protection for environmental defenders and affected communities from reprisals, participation, transparency, and accountability in environmental decision-making concerning climate change, the regulation of third-party conduct, particularly that of multinational corporations, the just and equitable transition to low carbon energy systems, and the decolonization of natural resource governance frameworks. So with that overview, I'd like to dive into the key takeaways that we can derive from the various AO processes and what implications they have broadly for climate justice and accountability. So as mentioned, ITLOS was the first of the 4 tribunals to deliver its AO, and its findings are expected to really provide critical guidance to the rest of the courts. Overall, it's my opinion that the AO does provide strong interpretations of what the law of the sea requires states in the face of the climate emergency, and also obligations in relation to other relevant international legal norms and principles. And while I don't have time to go over all of the aspects of the decision, I want to highlight some key takeaways. First, the ITLOS AO established that anthropogenic greenhouse gas emissions do in fact constitute pollution of the marine environment, leading to deleterious effects such as ocean warming, sea level rise, and ocean acidification. Accordingly, state parties to UNCLOS have a legal duty to take all necessary measures to prevent, reduce, and control such pollution, regardless of its source, whether that's land-based, aerial, or sea-based. Also, to satisfy that duty to prevent, reduce, and control emissions, the AO found that states must undertake measures that meet a stringent, objective standard of due diligence. ITLOS clarified that such measures should be determined objectively, taking into account the best available science. Notably, the court also found that the Paris Agreement does not exclusively or exhaustively define state obligations in relation to climate change, and that other international law, such as UNCLOS, applies. Also, the court recognized that while equity is central, all states are duty-bound to take action to reduce greenhouse gas emissions. In practice, legal obligations require states to not only drastically cut emissions, but also provide greater technical and financial support to nations with fewer resources and heightened situations of vulnerability, such as the small island states that originally initiated the process. For lack of time, I'll stop there, but I do want to point out that ITLOS in its AO did identify fossil fuels as a key source of anthropogenic greenhouse gas emissions, and also sounded a note of caution with regard to speculative technological responses to the crisis, such as marine geoengineering and carbon dioxide removal. Next, so as I mentioned, the next advisory opinion will be issued very imminently this Thursday, July 3rd. Keep it on your calendars. I know that's what I'll be doing all July 4th weekend, is reading probably 200 pages of this decision. And what makes this AO particularly significant is that it will interpret binding human rights law. And by doing so, the court will be setting legal guidelines that none of the members of the Organization of American States, which is more than 30 countries across Latin America and the Caribbean, can ignore. Its relevance also extends globally because fundamental human rights issues such as the rights to life, self-determination, health, healthy environment are protected not only under the American Convention, but also a lot of other international treaties and instruments, national constitutions, as well as local laws. And I don't have time to go into that much detail, but some of the key issues that CIEL and partners will be looking at when this AO is issued include the following. First, we expect the court to reaffirm that climate change affects the full range of rights of both present and future generations and gives rise to concrete obligations under human rights law, reinforcing state and corporate duties to prevent the conduct we know causes climate change, as well as remedy its destructive consequences. We expect that these duties neither start nor end with the UNFCCC and Paris, and that will be explicitly named, and that human rights law may require more from states than international agreements, including in terms of the level of protection and ambition of action. We also expect this court to address state obligations to regulate corporate polluters and private actors and ensure remedy for climate harm, meaning access to justice and full reparation for the consequences of climate change, including by and from the fossil fuel and agribusiness industries that have contributed the most to climate destruction, as well as obstructed climate action. It's also the view of many that the court won't be able to meaningfully answer the questions in front of it unless it explicitly acknowledges that states must halt and phase out the expansion of fossil fuels. And that requires taking proven science-based measures to rapidly reduce production use, as opposed to risky reliance on speculative technologies, which, as I mentioned, the ITLOS advisory opinion has already cautioned against. Many also expect the court to compile and harmonize the best available standards for protecting environmental defenders in the region, who are often, the targets of reprisals from governments. And hopefully those will be outlined. The court will outline those standards that are already incorporated in the regional Escazú agreement, as well as existing standards internationally and those established by the court. And so in terms of the ICJ, like the Inter-American Court, it's also expected to deliver its advisory opinion imminently, likely within the next couple of months. And while we don't know exactly what the court will say, certain trends and patterns emerged during the oral arguments last year that may essentially influence the scope of the judicial opinion. First, central to the oral arguments from states was the overarching question of what law governs state duties in relation to climate change. And this is a recurring question that has been central to every advisory opinion process so far. And it's important to note that while the US and other top greenhouse gas emitting states argued that climate obligations were exclusively limited to legal duties under climate treaties, specifically the Paris Agreement, a majority of states and international organizations advocated for drawing on the entire spectrum of relevant international law, and that necessarily includes human rights law. Some top emitting states also argued that the duty to prevent transboundary harm, which is a longstanding principle of international law, they argue that it doesn't apply to greenhouse gas emissions or climate change, but is rather limited to very specific situations of transboundary pollution. But you'll note that this argument actually conflicts with the opinion issued by ITLOS, which did affirm that transboundary harm the principle does in fact apply to anthropogenic greenhouse gas emissions, and thereby require states to apply a particularly stringent standard of care in addressing that pollution, given the severity of harm that can unfold. Additionally, during the ICJ oral arguments, calls for remedy and reparations went beyond just monetary compensation. They included structural measures such as equitable fossil fuel phase out, avoidance again on reliance of measures that might exacerbate harm, such as geoengineering, and also included calls for eco restoration and debt cancellation. So you might be wondering, again, I moved too fast. Why do the advisory opinion processes matter if they're not always legally enforceable? Well, first, they're very likely to guide climate litigation across jurisdictions and influence both regional and national policy. Essentially, the AOs will serve as a blueprint for climate litigation at the local, regional, and domestic levels, as well as set a foundation for climate policy making, grounding local legislation, as well as global negotiations in international legal duties. In fact, past ICJ opinions have been relied on heavily by regional courts, such as the Court of Justice of the EU, which in turn has impacted EU policy. And as mentioned earlier, the hope is really that the AOs will cut through the political inertia that have plagued the international climate negotiations and hopefully propel more urgent action, which is greatly needed. Also by spotlighting government's official positions on a wide range of factual and legal questions, the proceedings themselves provide important foundations for accountability. They also play an important role in shaping the narrative, building political power and will, as well as setting foundations for movements for climate justice. And just as an example of kind of the impact that advisory opinion processes can have, the ICJ's AO around nuclear weapons subsequently influenced treaty discussions around the interpretation of the Nuclear Non-Proliferation Treaty. And it also greatly influenced the public discourse around campaigns to ban the use of nuclear weapons and guided essentially the development of international environmental law principles. And as another example of advisory opinions in practice, the ICJ opinion in the Chagos case is another illustration of really the real world influence that AOs can have. Last year, the UK recognized the full sovereignty of Mauritius over the Chagos archipelago, essentially ending decades of colonial administration of the islands by the UK. And this decision came after the ICJ issued an advisory opinion in 2019, calling the UK's control of the Chagos unlawful and stating that it had a legal obligation to end the occupation. So to conclude, again, keep skipping slides. With the upcoming AOs, 4 different international courts have a once-in-a-generation opportunity to do the following: set a high bar for climate action that goes beyond the Paris Agreement and the UNFCCC, as well as voluntary commitments, but is guided by states' obligations under international law, international human rights law, the law of state responsibility, and customary international law, among others. It will allow the courts to signal to policymakers, as well as national courts around the world, what climate measures these bodies of law require both states and corporations to take, and that must be grounded in the best available science. The AOs will also define legal standards for holding states as well as corporate polluters like the fossil fuel industry accountable for climate destructive conduct. And lastly, they'll affirm the right to remedy and reparation for climate-related harm, especially for individuals and states that are on the front lines of the emergency, but have been pivotal for these international movements for accountability. I'll stop there and happy to answer any questions. Thank you.
Let's do law. Jeff Holmstead and I are going to be the last part of your presentation, building, by the way, on a great block of both international law and science, which I think is a great transition, because now we're going to be talking about federal courts and cases that shape what you think of as climate law. Now, those of you in the summer school, which I think is a great ELI program, we're kind of building a bit on the summer school program that you had if you listen to the Clean Air Act presentation. So some of the terms that we have, really, we're building on that. But I will say that this notion of carbon law is broader, way broader than what we're talking about today. Because we're going to be talking predominantly about Clean Air Act cases there, because that's how it has developed just through the Clean Air Act. But I can tell you, as a practitioner, it's way broader than that. It picks up energy law. It picks up national security issues, certainly public land issues. I have a client that's building a solar panels on top of a Superfund site, so it picks up circle law. So I want to just remind you that this area is extraordinarily broad and exciting because there's so many things happening. So I have so many students in the audience right now. In your lifetime, some of the things that we're talking about today will develop and mature, and we'll see more of. So it's a really exciting area to be in. As I start going through this, I got to do a shout out to Kirsten Lynn, who's in the audience, because she helped me put together all this. Without her, I would not be having all the slides. All right, look at the sliders. Lots of legal tools that are available when we start talking about climate issues. Again, I'm going to be focusing narrowly on Clean Air Act issues, but as I told you before, this is an area that transcends water, ESA, a number of different issues that you see in practice. However, let's go. Let's start out now with the beginning, if you will, of climate law. It didn't really begin with Massachusetts versus EPA, which is the grandmother or grandfather of what we're talking about. But back in the Clinton administration, a group of not big, but relatively small NGOs petitioned to EPA to regulate greenhouse gases as a pollutant. Carol Browner was then the EPA administrator. During a hearing, she was asked, can you do it? And she said, I don't know, I'll get back to you there. And she did what clients are supposed to do. She went to her general counsel, John Cannon, a former member of my law firm, and Cannon wrote a legal opinion that said, yes, you could do it under certain circumstances. You have to do certain things, but yes, you can. Nothing happened during the rest of the administration. Next administration comes in, the Bush administration, and they decline taking any action. Now, remember, Administrative Procedure Act, that's a final agency action that can be litigated. And it was. The whole notion of what can EPA do? EPA taking the position they could not do anything. Why is that a crazy position? Not really, because in between the time of these petitions and the time was coming to EPA, the Supreme Court decided a case called Brown versus Williamson, where the Food and Drug Administration was going to try to regulate all the tobacco industry, and the Supreme Court said, too big. It's too big. You have to be way more specific if you're doing something that big. By the way, does that sound familiar to you from more recent Supreme Court decisions, which I'll get to later when we talk about West Virginia? Anyway, Brown versus Williamson came out. And so that EPA read that, and the fellow to my left, then at the EPA office, wrote part of the opinion that said, based on Brown versus Williamson, there's other reasons we can't really regulate in that area. We don't have that kind of specificity. It's that case that got challenged, right? And remember, Administrative Procedure Act, arbitrary and capricious, goes before the DC Circuit because this is an issue of nationwide applicability. So as you know from past course, it can only go to the DC Circuit. DC Circuit writes 2-1 decision upholding EPA, but it's a mixed decision. The primary decision agrees with EPA. Justice Sentel, then the Chief Justice of DC Circuit said, no standing. Standing's relevant, hugely relevant. Dissent by Tatum, one of my favorite justices, who has now written a book because he's blind called Vision, where he talks about, among other things, this particular case. So we have a 2-1 decision. That's what goes up to the Supreme Court. Supreme Court takes cert over it. Jeff and I were both at the oral argument. I can tell you, after the oral argument, I didn't know which way they were going to go, Jeff. I did not know. That was a different court than it is now. Justice Kennedy was the very often in these 4-4, 5-4 decisions, the deciding person, and you really could not tell. But we did know standing was a very significant issue, certainly to the Chief Justice. And so out of this comes the decision now that you see, Massachusetts versus EPA, holding that EPA has the authority, in a way I'll come to regulate greenhouse gas as a pollutant. Here's the myth. There's a myth out there, and you'll see that in a lot of writings that says this is the domino there, that Massachusetts versus EPA meant right after that EPA had to go through and do all of the statutes, all the regulations that we see in place, that they had to do that, and that is incorrect. This is a first step, but the court is very clear that this is the authority to regulate. It's the authority to regulate, but you have another step that you have to go through in order to regulate. So anywhere you see Massachusetts EPA is saying this is the launch point, it's not. The launch point comes later. It comes later here. There. By the way, this is all during the Bush administration. They get Massachusetts versus EPA. Did they do anything? No, they did nothing about that. So that next comes the next administration. Now, this is the Obama administration. Lisa Jackson is now the EPA administrator. And not surprisingly, she is interested in the concept out of Massachusetts versus EPA. She goes through the APA procedure, notice and comment, deciding what to do, saying this is a scientific decision. From the very outset, this is not unimportant that the EPA at that time saw this as scientific because they were looking at the statute, the mobile sources. This is coming up in mobile source issue because that's how the petition came up. That's how it was decided. It was decided based on a mobile source, cars, trucks, engines. That's how it was decided there. And really, there's two parts to the endangerment finding. Everybody concentrates on the first one because EPA had mixed together 6 of the greenhouse gases, and that mixture is what they said. And look at the last clause there. The atmosphere threatens the public health and welfare. That's the magical thing they had to decide. But there was a second part, completely important in terms of the dominoes that come out of that. Because the second part says there's a causal relationship between cars and trucks and other motor vehicles that's what allowed the next step to go forward. All right, so it's this combination. It's a combination of the Supreme Court decision, Massachusetts versus EPA, still extraordinarily important, by way of 5-4 decision there. But it's that combination with the endangerment finding that allows EPA to go forward. All right, stop there. Is that it? We have a Massachusetts versus EPA and we have endangerment finding. Is that it? Is that enough now? Does that mean all of these stationary sources and all the mobile sources get regulated? No, of course not. You got to have regulations there. You got to go through other things, right? There's more to it there. But here's a missing part there. And I want to talk just a little bit about this missing part because it is relevant today. So Massachusetts versus EPA is a statutory decision. It's a statutory decision asking the question whether a greenhouse gas can be regulated as a pollutant under Section 202 of the Clean Air Act. It's a statutory decision. But remember back into your law school basics, there's more than statutes, right? There is a common law. There is, in some circumstances, a federal common law, perhaps, there. And that's what AEP versus Connecticut is about. Series of states and others sue defendants, in this case, AEP, not arguing the Clean Air Act, arguing a federal common law of like nuisance, that you are doing things harmful to our state, but not because of the Clean Air Act, but because of federal common law. This is the case that comes up to the Supreme court. And it is a unanimous decision there, written by not, an environmentally relevant person, Justice Ginsburg. But the basis for it is really important, because the basis of saying federal common law is, quote, displaced, kind of preempted. Why? Massachusetts versus EPA and the endangerment finding. Because what the Supreme Court says is they filled the void. There is no federal common law because EPA not only has the authority, they're doing things. They are doing things, and therefore you cannot bring a federal common law case. That's still good law today. What did I miss? What did I not cover when I keep saying federal, federal, federal? What am I missing? Yes, state, right, state issues. What does it say about state issues? Nothing. It does not cover state law.
Explicitly says.
Explicitly, that's right. There, that's relevant today too, right? As we come forward. All right, but back to the building block. So we have Massachusetts versus EPA, then we have the endangered finding, then EPA starts doing stuff. What do they do first? Of course, they do mobile source first. Why? That was the endangerment finding. The endangerment finding was mobile source. So they go out and do cars and trucks. And there is just an example of the things that they've been doing there. And those are a whole series now of regulations, not statutes, but regulations that have come out that have greenhouse gas requirements for mobile source. Once they do that, once that EPA has now not only had the authority, but now they're regulating greenhouse gases as a pollutant, as another one of the dominoes. That now gives them the responsibility of doing it elsewhere. What's elsewhere? Permits. What are permits? Stationary sources. So that's the complication of trying to work anytime you do with particularly carbon dioxide. There's a lot of carbon dioxide. This building emits carbon dioxide. Me and you emit carbon dioxide. Those are a lot of carbon dioxide out there. When we talked about stationary source issues and you talked about major source, what's a major source? Depending on the source, it could be as low as 100 tons per year, maybe 250 tons per year. That's nothing in carbon dioxide emissions, absolutely nothing. So that's the problem for EPA. If EPA says, I have the authority and now I should do something for stationary sources, how exactly am I going to do that there? So they come up with something called the tailoring rule, where they're not going to do down to 100 or 250 tons per year, but they're going to phase in, still pretty high numbers, phase in things like, let's look at the numbers on my slide, 75,000 tons per year, 100,000 tons per year. Compare that to the normal major source, if you're doing that for in the criteria pollutants, NOx or sulfur dioxide, now they're much lower, right? These are big numbers. That's what goes first to the DC Circuit, and it goes in a grouping of cases, issues. The endangerment finding is getting challenged. The stationary source issues are getting a challenge. That's what goes to the DC Circuit, again, because they have nationwide jurisdiction of clean air cases there. And the DC Circuit upholds virtually all of this. They uphold the car rules, they uphold the endangerment finding, they uphold the stationary source issues, and that's what goes up now to the Supreme Court in a case called UARG there. So I have it on your slide, and it's a long and complicated case. The Supreme Court, out of all those issues, only looked at stationary source issue. And it's written by Justice Scalia. And if you know anything about Scalia, you would say the chances are of having something that goes beyond the statutory authority, this whole tailoring issue, did not receive a warm embrace. And they looked at it and said, how exactly can you change the threshold to be that high? Where do you get the authority for that? And so that part of the rule on handling stationary sources was invalidated. However, there was always many of these climate cases, there's a however, and this is a however. Well, it turns out that if you were a major source, you were for, a number of other issues that you know about. You could be a major source for, a whole bunch of sulfur dioxide and so forth. If you were already a major source, then it allowed to include greenhouse gases in those that were already being regulated. Then you could do that. So a number of sources came out of this decision as we're being required to do in your permit process, greenhouse gas issues, but not the way it started out. It started out very big. And it turned out much smaller than that. All right, so what have we done so far? We did cars, we did stationary sources, that's out of New Source Review and those sorts of programs. What about New Source Performance Standards, which applies everywhere? Well, they did. This is the 111 process. So if you're at EPA, and you're going to look at New Source Performance Standards, and you're figuring out, because 111 process looks fundamentally at industry-wide issues. What industry do you start out with? I don't remember where I saw this, but it was asking this bank robber, why do you rob cases? Why do you rob banks? And the guy said, well, that's where the money is. And it's a little bit like that here too. Where would you start out with? Power plants. You start out with power plants because at that stage, it's not true today, by the way, at that stage, power plants were the largest single source of greenhouse gases. What are they today, by the way? Cars and trucks there. All right, so they do it. They do it in something called the Clean Power Plan, which when I was a justice, I defended that unsuccessfully, I might add, there. But let me just tell you, because again, some of these things are still with us. Very ambitious, I will admit that. The Clean Power Plan was very ambitious, had building blocks that would allow you then to lower your greenhouse gas emissions. And one of the building blocks would actually have pushing from coal-fired power plants to natural gas, because natural gas has 50% less CO2 emissions. And that was thought of as generational shifting there. And so while this was happening, that went to the Supreme Court, and Supreme Court stayed one of the very first of these stays. Now we're seeing more of it, but at that stage, that was very significant that the Clean Power Plan was in fact stayed by the Supreme Court. Did not, by the way, these stays like that does not mean the case stops. That case did not stop. We had 7.5 hours of oral argument en banc before the DC Circuit. And then administration changed. So now this is Trump won very quickly. Now surprise, because he campaigned on this. Trump eventually set aside the Clean Power Plan. So there was never a decision at that stage on the Clean Power Plan. And the Trump administration comes out with their own. They come out with their own called the Affordable Clean Energy Act, which, as you would imagine, did less. There was a whole issue then, because you're in the structure of Section 111 that says you have to have the best system of emission reduction. That was the magical language. And the question was, well, does that have to be only at the power plant? Or can you go beyond the power plant? Clearly, the Clean Power Plan went beyond it. Clearly, the Trump rule did not. It stayed within those boundaries. But then that question was that good enough there? That question gets decided by the DC Circuit. They invalidate the Trump plan. And what happens? West Virginia versus EPA. Now, West Virginia EPA probably in the last, couple of Supreme Court terms may well be the most important, certainly the most environmental case, not the one that's getting cited the most. That's Wilbur Wright. But West Virginia versus EPA is getting cited all the time. And only a few of them are for environmental cases. It's a case that's having issues way beyond the environment. But just for a minute, think back to what I told you about Massachusetts versus EPA and Jeff Holmstead writing this memo that says EPA can't regulate because they don't have sufficient statutory authority based on the Supreme Court decision of Brown versus Williamson. Remember that. Now we have Chief Justice Roberts writing about clean power plants and holds, without looking at the statutory authority of Section 111, does not really do that, but says only that in these cases that are so big and affect the economy in such a big way that Congress is going to have to speak with very specific authority, very specific language, and they did not here. And so invalidates it, not looking for at the statute really, but rather looking at back what we saw on Brown versus Williamson. So that's what I saw when I'm talking to you about we all talk that Massachusetts versus EPA is the beginning, and now West Virginia is sort of the other end of the bookend. There's a lot of similarity between the two. What I'm going to do now is give you spin-offs from these cases, spin-offs from Massachusetts versus EPA, not really a spin-off from exactly from West Virginia, but things that are happening now. I'm going to hold the issue of the endangerment finding, because remember I told you that's still in play, and then ask that Jeff does that because it's in play right now. There. All right, here are things that have happened right now. Look on the left. Just because West Virginia versus EPA went into effect did not mean that EPA was off the hook. EPA still had to have a regulation in this area. They still do it. They tried to do it in 2024 now for existing coal and new gas plants there. That's been litigated. And if you look to the right, you'll see that Trump has proposed to repeal that there. What about air toxic? Air toxic, the most dangerous of things, so that the pollution abatement equipment for air toxics is the highest, as it should be, called LAIR, lowest achievable emission rate there. What's an air toxic? Mercury. So mercury has been kicking around for quite a long time there. It's gone up to the Supreme Court already there. The Supreme Court saying, even though it's an air toxic, you still have to consider cost in that issue there. That's a good question. When they get to you, Jeff, just ask whether you have to consider cost and endangerment finding, because they did not.
Oh, there's a degree of disagreement.
There. And so the Biden administration comes up with a strengthened mercury rule. The Trump administration has already granted an exemption, not exemption, an extension for that, and proposed a repeal of that. Here is cars, the CAFE standards, which have been ratcheted up, significantly ratcheted up. Look over there at the far right, looking at what it would be under the Biden standards, miles per gallon, 54 miles per gallon in 2025. I have a C30 Volvo. I'm getting like 25 miles per gallon. I'm not getting anything close to that there. But you see already the rollback. You're following, should be following the whole issue of California waiver. The Clean Air Act allows California to come up with its own standards. In order to do that, then EPA has to agree to waive that. In the Biden administration, they did agree to waive that. That's being litigated there, but there's also been congressional action invalidating of that waiver. That's a little bit complicated because the litigation continues, but this should be on your look at because it flows again from Massachusetts versus EPA as it did in the beginning. Here's another one, methane rule, another greenhouse gas issues, without a question, a very significant issue. The EPA rule came out November 24. The Congressional Review Act has already prohibited that rule from taking effect there. I'm going to do this one. I want to do just two more quickly, just to have this, so that you're thinking about it. So this is a more recent Supreme Court decision, 7 counties infrastructure. It's a railway that goes considerable part of Utah, their Colorado counties. They didn't like that because they said all that railway traffic will have an adverse effect on us. So they challenge the NEPA decision. So this is a NEPA decision, not a Clean Air Act decision. They challenge it saying, well, it isn't where the project was, but the indirect effect or the downstream effect will affect us. And so they go to the Supreme Court arguing that should have been considered in the environmental impact statement, the downstream effect of that project. And the Supreme Court said no to that. Supreme Court said, no, we're just looking at the project. We're not looking at upstream. We're not looking at downstream effect. I think this could have an effect as well on considering climate issues inside of a project, whether or not you have to consider them. Sometimes, and there's case law out there, sometimes, of course you do, because it's right at the project level that there will be a increase in greenhouse gas effects. But what if it's not? What if it's really downstream? I could see an argument that this case, at least for EPA, would be relevant. And the Council on Environmental Quality during the Trump administration has rescinded the guidance on climate issues in NEPA. And so this is a whole nother new area that we will be talking about in probably future summer classes. One last one there. And this will be ultimately a transition to Helene and others. And that is, here's another Supreme Court case. It's a Supreme Court case dealing with Baltimore. Baltimore City sues a number of oil and gas companies, arguing state law. State law allows us to bring action. State nuisance law, state common law allows us to bring a case against oil and gas CO2 emitters. This thing bounces up and down as to whether or not that's going to go in state court or federal court. That is the issue. So why would BP want it to be in federal court? Remember, AEP says that it displaces, preempts federal common law. So if it gets into federal court, of course BP wants to be in federal court. That's a way better forum for them, right? Because of the AEP decision. And then what would Baltimore want? They want to keep it in state court, right? So that's the case was filed in state court. It was removed to federal court. And the issue of Baltimore is just really removal issues. What law applies to that? That's not why I'm giving you that case. I'm giving you that case to let you see that there's a lot of these out there. There's a lot of these state court cases out there and a lot of issues going back and forth, federal or state. But we haven't had a merits case before the Supreme Court yet on that issue. But that's happening, and it's a significant issue. All right, with that in mind, so we've done mobile sources, we've done stationary sources, we've done permits, we've seen Massachusetts versus EPA as a start. We see the challenges of West Virginia. We see new things happening. But I was reading in the paper, Jeff, just reading, that there's a move among some people to redo the endangerment finding there that was done in 2009. Can you talk about that?
Well, it looks like you and I read some of the same article. It's a pleasure to be here. I wanted to just give 30 seconds to those of you who are mostly just starting out in your legal careers to just explain why I became an environmental lawyer. I went to law school. I had no idea there was such a thing as environmental law. If there was a class, I didn't take it. And I clerked. I was working for a big New York law firm. And then through an unusual series of events, I got an opportunity to go to the White House in the George H.W. Bush administration. And my boss was the counsel to the president, who was intensely interested in Clean Air Act issues. And he asked me if I'd be willing to spend some of my time working on these issues. And I had no real interest, but I did want to work in the White House. So I said, of course, absolutely, I would. And within just a few months, I was spending almost all my time on Clean Air Act issues. And when Dorothy Beveridge was not reelected, I had an opportunity to go back to my old New York firm. But what I had learned is these environmental issues are way more interesting than any other issues I had encountered. And it's a combination of science and economics and law and politics that makes this area of the law enormously interesting and important and satisfying. With that by way of introduction, my role here is just to talk a little bit about what's happening in the Trump administration. First of all, I think I have a news flash. I don't think anybody else mentioned this, but this morning, EPA transmitted to OMB for review a proposed reversal of 2009 endangerment finding and a revocation of the Biden administration vehicle pollution standards for CO2. So that is now pending at OMB. I'll talk a little bit why I think their reversal of the endangerment finding will never stand up in court. But there's a second rule that's also pending that was transmitted to OMB today, and that is EPA's proposal to revoke the greenhouse gas reporting program. And that is not such a frivolous case. When EPA adopted the greenhouse gas reporting program, they did so based on Section 114 of the Clean Air Act, which had never been used before to establish sort of an ongoing industry-wide program of reporting. And that will be interesting to see how that plays out. The administration says that they're planning to eliminate that. So with those two bits of information, I just have sort of 5 points I want to cover. I'm going to just quickly tell you those 5 points, and then I'm going to come back and spend more time on the administration's efforts to reverse the endangerment finding. And actually, there's not just one endangerment finding. There's actually been 4 separate endangerment findings. People tend to refer to the 2009 endangerment finding, which really started this all. That was specific to vehicle emissions, and then there's been some other ones as well. So point number 1 is I represent a lot of industry clients, and none of our clients asked the administration to reverse the endangerment finding, and in fact, they've been quietly opposing that for a couple of reasons. So what's going on right now is not in response to industry, and industry, in fact, has been quietly trying to talk them out of that. So that's point number 1. This is not something that industry wants to do. The second point is, I'm going to talk about 2 different endangerment findings. One, they've already proposed to undo. The second one, we expect that rule probably in the next, as soon as that clears OMB review. I think it's pretty unlikely, based on the theories they've used to reverse the endangerment finding. I think it's very unlikely those will be upheld in court. I think, it's near 0 chance in the DC circuit, and I think maybe a 1% chance in the Supreme Court. In fact, it seems like such a uphill battle, tilting at windmills. I suspect that they may be trying to use this as a stalking horse to get the Supreme Court to relook at Massachusetts versus EPA. I do think that if Massachusetts versus EPA were to go to this Supreme Court using the major question doctrine, they would agree with me and say Congress never intended CO2 to be regulated under the Clean Air Act. There's no indication that Congress had that in mind. The programs were not really designed for it. But that's not where we are. And I think it's very unlikely that even this support will reverse the Massachusetts versus EPA. And John and I have talked about that. And I won't go into the reasons why, but they're not going to get the endangerment finding reversal upheld. And I think it's highly unlikely the Supreme Court will agree to look at Massachusetts versus EPA. But I do think that may be what they're trying to do.
But don't you think that's in part because that was a statutory decision?
Yeah.
It was a constitutional decision. Who knows? That would be a different.
Right.
But because it was statutory.
I can't think of any statutory interpretation decision that they've overruled.
No, I agree that they've overruled. I
Right,
agree.
and someone actually, in the recent, I can't remember the case, in a recent oral argument, someone suggested they should do that. And Chief Justice Roberts said, we don't do that. He basically said, well, we don't, and the theory basically in the Supreme Court is, if we get it wrong, Congress can tell us. But if it's a constitutional decision, we're the only ones who can correct that, and so we do sometimes famously overrule some of those decisions. Okay, my last two big picture points before I talk a little bit more about the endangerment finding. Massachusetts versus EPA is enormously important and celebrated, but I think it has accomplished very little that wouldn't have already happened anyway. And let me explain why that is. First of all, changing our energy infrastructure is a long-term endeavor, and changing our automobile fleet is a long-term endeavor. And it is not helpful to have regulations bouncing back and forth. You know, famously, the Biden administration did the Clean Power Plan, the Trump administration undid it. I'm sorry, that was Obama. The Biden administration comes along, they have their new power plant rule. That's going to be undone. And I do think that the undoing of that will stand up in court, as long as they don't rely on the reversal of the endangerment finding. The same thing with the vehicle requirements. The Biden administration, the Obama administration proposed very aggressive, at least in the out years. The Trump administration undid those. Saw the same thing with Biden, and again, Trump is proposing, soon to overrule those. So that's one reason. But separate and apart from that, the Clean Air Act really was not designed to deal with CO2 emissions. And I guess my contention is, when you look at the improvements that have been made in vehicle emissions, that could have been accomplished entirely under the CAFE standards. There's very little that's resulted from EPA being able to, there's been a lot of controversy, and they have had some success in phasing out high GWP refrigerants in automobiles that EPA has done.
Yeah.
But for the most part, the CO2 reductions could have easily been, easily no, because there's a lot of pushback, but they had authority to do that. You look at the methane standards for oil and gas, and again, there's been toing and froing on that, but EPA could have achieved all of those by regulating VOC emissions, because methane is a volatile organic compound. EPA routinely regulates volatile organic compounds from oil and gas operations. Everything about reducing methane emissions from oil and gas has to do with preventing leaks and fixing them very quickly. That's the only way to reduce methane emissions. That's the only way you reduce VOC emissions. And so EPA could have, without getting into the mess of regulating methane, they could have accomplished the exact same thing. And when it comes to the power sector, I can say with great certainty, as someone who represents power companies, that none of the power sector regulations have really had an impact on the power sector. And John talked about the PSD program, and it is true that as soon as EPA regulated CO2 emissions from mobile sources, that became a regulated pollutant. And even after the UR decision, anyone who was a major source of other pollutants had to get a permit, and that permit had to include the best available control technology for reducing CO2 emissions. I've reviewed, I can't say I've reviewed everyone, but as far as I can tell, none of those back decisions required the companies to do anything they weren't already going to do, because none of them have required CCS. It's all about using high efficiency technology to make sure that so those back decisions have not accomplished anything yet. Now, that may change, because for a few types of sources, I do think the carbon capture and sequestration has been demonstrated. And so I think new permits for gas processing plants, for ammonia plants, for ethanol plants, I do think we're likely to see some back decisions that require. So that will be an accomplishment of Massachusetts versus EPA. But at this point, and maybe I'll be proven wrong, but at this point, it has not amounted to very much in terms of reducing CO2 emissions or greenhouse gas emissions. Other things have, and I will say, especially in the power sector, all of our clients are under pressure from customers, from ratepayers to phase out their emissions. And they're not doing it as quickly as people would like, but the change in the US power sector has been pretty dramatic over the last 15 years.
And wouldn't you also say that there are market forces at play right now? I mean, we haven't seen another coal-fired power plant built in the last decade, but it's because natural gas is so much cheaper.
Natural gas has made a huge difference. The fact that when you and I were working together in the federal government, I got pulled into interagency meetings to talk about the natural gas crisis. Natural gas was like $12 an MCF. And anyway, the fracking revolution has probably done more to reduce greenhouse gas emissions than, sorry about that.
Bring it to the microphone.
I have a little implantable device to, if it's off every once in a while. But market forces have made a significant difference, and I think that's a good news story. And then my final, maybe sort of provocative statement to make in front of this audience is I don't want to minimize, I think, all the important work that's being done in courts and in regulations to try to keep to try to keep the pressure on for industries and companies to reduce their greenhouse gas emissions. But ultimately, I think the only way we address the climate crisis is through technology. And so what I've been a big proponent of in my career is trying to fashion regulations and other government programs that will maximize the likelihood that the US ingenuity will find ways to produce electricity and to power transportation that will be cost competitive with fossil fuels. Because unless that happens, it's going to be very difficult to see how the developing world is not going to continue to increase their emissions. So I would encourage you to think about that too. What are the kinds of legal frameworks that can be put in place and the incentives that would lead to the development of new technology? And I tend to be a technological optimist, and I think there are some important things that are coming along. Okay, that was my introduction, and I took up half of my time. I will go very quickly through my slides. I swear I'm pressing the right button.
I can do them here.
If you could
if you
just
want.
go through.
Now they don't move at all. They don't move on here either. All right.
There we go. There are 6 different provisions in the Clean Air Act that require EPA as a precondition to regulating to determine whether a pollutant or an industry produces air pollution that is reasonably anticipated to endanger public health or welfare. These are the 2 most important ones. The first one is from section 202, which deals with mobile sources, and it's pretty straightforward. It just says the administrator shall prescribe standards for any air pollutant from motor vehicles, for any pollutant which in his judgment or her judgment causes or contributes to air pollution that may reasonably anticipated to endanger public health or welfare. So that's the 2009 endangerment finding. That's the one that really started everything else off. Before EPA could regulate the power sector or methane emissions from the oil and gas sector, they also had to deal with section 111B of the Clean Air Act, which has another endangerment finding. And this one is worded differently in 2 respects. It doesn't say that the administrator shall set standards for air pollutants if they endanger public health or welfare. It says the administrator shall basically regulate a source category if in his or her judgment, that source category causes or contributes significantly to air pollution, which may reasonably anticipated to endanger public health or welfare. The first one is a mandate to regulate pollutants directly from mobile sources. The second one has to do with this list. That EPA has to create a list of source categories if the administrator finds that it may reasonably anticipate it to cause or significantly contribute to air pollution. This second one is what I call the power plant endangerment finding. And that's what the administration has said they're going to reverse in their recent power plant rule. And their interpretation is, even though it has to do with listing a source category, they say you independently need to make a finding that before you regulate a pollutant from that source category, you need to make a finding that it causes or significantly contributes to dangerous air pollution. And neither the Biden administration or the Obama administration actually did that. They took the position that they didn't need to, but then they said, well, if we had to, we would still determine that it significantly contributes. And that was a wise thing to do. So this administration has come along, and this administration has come along, and I'll tell you how they prefer to reverse that in a way that I think will not stand it for. But I want to just tell you, somehow I eliminated a slide. You know, I had some great quotes, I thought, from EPA's press release. This is not the best one. When EPA announced back in March that it was going to reconsider the endangerment finding, it was highly critical of the Obama finding, because they said that the Obama administration did not consider all the downstream consequences, and in particular the cost. And one senior official was quoted as saying, well, I've always said that it was unlawful because they refused to consider the cost that it was imposed and the downstream consequences. But yeah, here we go. This is the quote I was looking for. Since 2009, I've consistently argued that endangerment requires a reconsideration of downstream costs. And then we have, under the enlightened leadership of President Trump and Administrator Zeldin, the time for fresh thought has finally arrived. I want to just go back at both section 202A1 and section 111B A1, and it sure reads to me like this is entirely a scientific finding. And the other thing, of course, is when EPA actually regulates, whether you're looking at vehicles or power plants, they explicitly have to consider cost in making those determinations. So when EPA makes the endangerment finding, they have no idea what the ultimate cost is going to be because they haven't issued the regulations yet. And are you looking at the cost that the Obama administration would have proposed, or the Trump administration, or the Biden administration? There's no way to know ahead of time. And yet this is something they have to do. So there's no way practically they would know what the cost is. And second of all, you may have heard of this case called Loper-Bright, John, where they ask you what the best interpretation of the statute is. There's various things they've said. And one of the things they've said is, a long-standing contemporaneous interpretation bears a lot of weight because we presume that that was the meaning that Congress intended. Well, for 45 years, EPA said this is entirely a scientific finding. Massachusetts versus EPA basically said it was a scientific finding. And the DC Circuit, when the endangerment finding was challenged, specifically held that EPA was not allowed to consider any of the downstream consequences of regulation. They had to make it purely an endangerment finding. So that's reason number one why I think that they will not be successful. Oh, and I've used my time up already. I want to just show you one more slide. So these are the reasons that they gave for proposing to reverse the endangerment finding for power plants. Cost-effective control measures are not reasonably available. And then this is the one I like. So they're reversing the endangerment finding because the administrator has discretion to consider policy priorities. And this administration's priority is to promote public health or welfare through energy dominance and independence secured by using fossil fuels to generate power. I can see why some political official wanted to say that, but it is clearly an invitation for the courts to, I mean, these rationales make no sense under the statute. So, I will turn my time over to you with the final prediction that we will see rules from this administration. Industry is not really sought. They would like regulatory relief from cases where they thought the Biden administration went overboard, but it's not industry that's pushing for the reversal of the naked findings.
So I have a little presentation too, and I want to save time for myself, but why do you think it's happening then? If it's not what industry wants?
There is there's a relatively small group of people who were enormously influential, who were sort of pushing this idea. There's some people who have been pretty outspoken. I don't want to name any names, but those of us who work in this area know, there's a handful of people. And my understanding is at this point, they are not really working with any of the career staff. They have, a few political officials that are kind of working on these issues. And that's not really a good remedy, a good recipe for getting things,
But this is back to my myth point that I said at the outset, I think it's a myth, that if the endangerment finally came tumbling down, then all of a sudden all the regulations come tumbling down too. And I think that's just not correct as well. So we'll see. But anyway,
So I'm gonna spend I'm gonna go really fast in the interest of time, but that was a lot on federal policy, which of course is not the whole picture in the United States. States have been taking their own actions for 20+ years related to this, and perhaps will continue to more if some of these things get rolled back at the federal level as well. And then, as has been alluded to in the US, these issues are coming to the courts all the time as well. So I'm going to be really brief. We could spend a whole summer school session on state regulations, a whole one on climate litigation, and I'm going to do them in 5 minutes, basically. But so starting with state law, I'm not going to do all of these. There's actually 2 full slides here of examples of some kinds of state policies that relate to mitigating emissions or adaptation. So one that you probably have heard a lot about are greenhouse gas reduction targets. The goals of these is to set either a binding and in some states a voluntary goal to reduce emissions over time. What are usually referred to here are economy-wide. These are sort of, you have to hit this as a state. We're going to talk also, there's targeted ones. So the goal might be to reduce emissions by 40% by 2030, looking at a 1990 baseline, and by 85% by 2050. That's actually New York's law. Other states have different baselines, different targets. California isn't one. They have a net zero target, and I think that Marisa used the term net zero too. Just to be clear, net zero is not no emissions. It is ensuring any emissions that happen are reduced by the same amount to not. There are also, over here, whole nother list. There are complementary policies that are more targeted to a sector. Like I mentioned, I think that these might actually still be on the first slide. Renewable portfolio standards, for example, that is aimed at getting utilities to source a certain percentage of their electricity from renewable energy sources or clean energy sources. Those also differ by state. Highlighting this one because DC has had one of these laws since 2005, although it's been amended several times since then. The goal under that law is to make electricity 100% from renewable sources by 2032, which is not very far away. And then by 2041, 15% should be coming from local solar power in particular. So ambitious goals by some of the state. Energy efficiency standards are another example. Those could be targeted at a particular source or sector, like buildings or your appliances. There's a good example of adaptation and resilience. Resilience Florida has a program. So these are designed to reduce the risk of climate change. They could be extreme heat, flooding, sea level rise, like Marisa talked about. They focus on providing funding through various grants to help coastal communities and rising seas in Florida. So it's not also a sort of red state, blue state. Lots of states are taking lots of actions. You tend to hear about the most high profile ones, like John and Jeff were debating, but there's a lot happening at the state level, and it's happening at all states. I could talk again, all of these. The one you probably have heard the most about recently, though, are these super fund laws. These have been in the news a lot because recently Vermont and New York both enacted these. They're also being considered in California, Maryland, and Massachusetts right now. These are based on the 1980 Federal Superfund Law, or CERCLA, which created a tax on the chemical and petroleum industries and that provide broad federal authority to respond directly to release or threatened release of hazardous substances. CERCLA established prohibitions and requirements for abandoned waste sites also, but it also provided for liability for persons responsible for the hazardous waste. And CERCLA is set up as a strict liability, joint and several liability, and retroactive. That's sort of three powerful tools at once in terms of liability. And so it means one party could be held liable for the cleanup of an entire site, whether when you can't separate who caused the harm. So the purpose of the state Superfund laws is also to collect payments from responsible parties for climate change. Who is a responsible party depends on the amount of emissions and the time range considered. Even under these two laws, we don't really know the answer to that now. The Vermont law looks at parties that have emitted more than 1 billion tons of CO2 equivalent between 1990 and 2024. And then there's going to be an impact analysis of what has the impact been on Vermont. So the Vermont Department of Natural Resources is going to be sort of making these allocations and assigning basically responsibility for impacts in Vermont. New York went ahead and set a number for their fund of $75 billion that's supposed to be distributed over the next 25 years. And they are also, by agency rule, going to determine who's a responsible party. Both of these laws have been challenged in federal court, both by private parties and lawsuits from the Trump administration. So don't know where these are going to go, but these have been sort of an inventive new wave that is very recent and has gotten a lot of press. And actually, I think that here we had the ELI webinar. If you're interested in these laws, you can do a whole hour on them, or maybe even an hour and a half. And the last thing I'd say about state law is that this list doesn't include other things being driven by climate change, like real estate, insurance, things like around flooding. These are like really more targeted directly at climate. And this is a theme I'm going to talk about quickly with litigation as well. So what I'm going to use here, climate litigation, what is it? What do I mean by this? These issues are coming to the courts. It takes a huge variety of ways are coming to the courts. There's a lot of challenges to the laws and policies you've heard about here on the federal, on the state side, like I just said, but there are also thousands of cases related to climate impacts, like hurricane, flooding, drought, and to climate solutions also, like related to the energy transition, cases about permitting, challenges to wind and solar projects, insurance, real estate. These are all implicated by climate change, and the cases are already here. It's a giant body of law already, and it's likely only to increase. So where are these cases? What do they involve? What are the trends? Most of the information comes here. That I put this up because some of you are students and new in the field. This is the Columbia Law School Sabin Center for Climate Change Law, hosts and maintains a database of these cases. There's two you can see, a global and a US. They're really user-friendly, highly recommend them. You can search by term, and they also have related documents to the cases there, which if you don't have access to PACER or have to pay for documents, very, very useful. And they also have descriptions of the cases. They do a little write-up of what happened in each case. So very, very helpful. So in that database, how many cases are you going to find there? As of May, there's now just over 3,000 cases in that database. It is worth noting that almost 2,000 of the 3,000 are from the United States. I want to make three sort of points
about this slide. First, you can see the overall trend increasing from a handful of cases in the early part of the century to at least 200 filed each year since 2019. Where are the cases again? They're predominantly in the United States. The United States is blue. Like I said, it's about 2/3 of the cases. And in the US, 40% or so are in state courts and the rest are in federal courts. And the third thing, which is really the theme, if I can leave you with one takeaway, is the Sabin Center actually defines a climate case very narrowly. And certainly undercounts the impact of climate change on courts dockets. To be included in the Sabin Center database, it has to be brought before a judicial body, and climate change law, policy, or science has to be a material issue of law or fact in the case. So it doesn't include cases that have a direct impact on climate, but don't raise climate as an issue. Like I just said, like permitting a fossil fuel fired power plant. That is not a climate case under the Sabin Center definition, but certainly has impacts for the climate. Same thing like an insurance claim for coastal flooding. Also, it's an insurance case, climate change, if it's not a material issue, wouldn't be in the Sabin Center. But the outcome of the dispute has relevance for mitigation and adaptation, like Marisa talked about. Here is another way to view this information. That's just to show that 70% or so of the cases are in the United States, and it's the vast majority. Obviously, the rest is all illegible. But the point of the slide is to illustrate just how many jurisdictions around the world do have cases directly involving climate. And it's now more than 50 states, to use Upasana, countries have litigation in addition to the international courts that she spoke of. Focusing on the United States, this map breaks down where the cases are, the Sabin Center by case. As you can see, even with the relatively narrow definition, we already see cases meeting their definition in all states but one. That one state is New Hampshire. And this again will sort of highlight this narrow definition because the New Hampshire Supreme Court has decided a case about a transmission line project that involves sending hydropower to New England from Canada. So arguably that's a case about renewable energy. But since climate wasn't a central issue in the case, it's not in the Sabin Center database, and New Hampshire is your lone no state. But that doesn't necessarily mean that courts in New Hampshire are not grappling with lots of issues that are related to climate. What are the claims in these cases? They're legion. There's no typical case here. There's constitutional cases, statutory cases, regulatory cases, administrative cases, common law cases. In the US, actually the one that is the most prevalent is NEPA, which John mentioned, and similar state environmental impact assessment laws. Actually, interestingly, CEQA, the California review law, has a lot of cases, which is actually probably why California is the darkest color on here. And if you read the news today, another news item is California is actually poised to make a lot of changes to CEQA that may actually lower their number or how dark their that orange is on there. But as I mentioned, with both New Hampshire and the definition, there are lots of cases where climate still is relevant. I was preparing some stuff for Indiana, and I ended up with a divorce proceeding case where the couple was arguing about the proceeds from the wind turbine that they had installed on their property. So, climate is playing a role. It can be in any case. A couple of other examples. There's a Utah case that has gotten a lot of press about the water levels of the Great Salt Lake. That is not in the Sabin Center database. That is not considered a climate case, but certainly climate change is a contributing factor to the levels in the lake. Maui wildfires is another good example. There have been claims brought against utilities for failing to prepare for the increased risk of wildfire. Actually, there's cases that have been brought after the Los Angeles wildfire that are similar. Though there's also thousands of insurance claims about those. Those do not make the database either. So the result of that is that we have kind of an incomplete understanding, and with it, probably a little bit of an underappreciation of how much the impacts that Marisa was talking about are changing what's going on in the courts. And a lot of things like the endangerment finding, take up a lot of
aired in the media, but I encourage you to think locally and regionally, and see how much is being impacted by things changing. I'm gonna just close, these 3 slides are just demonstrative. We're gonna get to illegible here too, so I warn you. That's sort of by design, that just to show the sort of wide ranging ways that these issues are coming up in everyday life. So this shows the impacts, and some of which Dr. Borreggine talked about, or that you've read about, or that you've experienced: extreme heat, hurricanes, drought, wildfire, flood. The next one, here we go, shows how these touch on the laws in multiple ways, like droughts affect water rights, agriculture, land use, hurricanes implicate planning, post-storm damages, construction, flooding implicates property rights, ecosystems. You get the picture, on and on, right? And the third, and this is just a visual way, shows how much climate impacts are changing the nature of litigation across the country. So this has a case, you're not meant to read them or go read them, but that for every one of the impacts that goes out to legal issues, goes out to resulting in litigation. And I think this trend is likely to only continue as all these policies take effect in states and feds, are just going to lead to more and more of these sort of controversies. And so just, it's a big area of growing law, and we encourage you to think of it broadly. And I thank all of the panelists for their participation. We're at time, unfortunately, for questions, but I'm going to close, and those in the room, we can stick around a little bit, a few minutes, or at least whoever can. But I want to actually just sort of close and ask everybody to answer a question if they could. So I just ran through all this stuff, but there's really just so many things happening right now. I feel like when you, in the world and locally, regionally, everywhere. So leaving this and thinking about folks sort of trying to absorb it all, if you just have to pick 2, everyone gets the top 2. So it's hard, I know that. What developments would you suggest that people here pay attention to in the coming weeks and months? So we'll take, the rest of, what are you looking for in the rest of 2025? And does anyone is, what 2 things you encourage people to look at, or you think are at least very important, if not most important?
One of them happening right now as we sit here, the Senate is considering their large tax bill. There's an enormous part of that dealing with renewables and indirectly greenhouse gas issues. However that comes out, whether it passes or it does not, whatever it does, it will have an enormous impact on future issues in the country. So
FEMA. I'm biased because I used to work there, but just looking ahead to the hurricane season that we're already in, and how cutbacks to hazard mitigation funding and hazard mitigation programs at the federal level are going to play out this summer, especially with the upcoming meeting of the FEMA Review Council that is expected to provide their recommendations by the end of the summer for what will happen with FEMA. As a climate scientist and as just a human person, I'm concerned about what's going to go on there.
Awesome.
Sure. I mean, you all know what I'll be doing on July 3rd and 4th, and probably for the rest of the summer with the ICJ opinion. And I know it's a very abstract topic, international law and international jurisprudence, but I think it really exemplifies that states countries on the front lines of the climate emergency are really fed up with how little has actually been achieved through international negotiations. And I think we're seeing a trend towards more accountability, including, more interest in something called the Fossil Fuel Non-Proliferation Treaty. And so we're seeing an evolution of law that will go past sort of voluntary commitments and really try to hold polluters to account. So stay tuned on the AOs, and CIEL will be definitely putting out analyses in the next coming months.
But I will point to the cases we'll see over the engagement filing. I think they'll finalize at least one of those rules this year and the other one next year. The other thing though that I think that is worth paying attention to is just the development of new nuclear in the United States. We really haven't seen anything and there's a lot of very interesting projects that look like they could be economic and they won't be built this year, but there may be the permits and funding.
Yeah, we can close things out. Just thank you all so much. Thank you, Helene, Marisa, Upasana, John, and Jeff. We so appreciate having you all here today. And for the folks online, sorry we couldn't get to your questions. For the folks in the room, if you want to stick around, I think hopefully some of our panelists will be around for questions. But just a huge thank you, and we will see all of you next week for Clean Water Act online, and then the following week in person again for environmental justice or online if you're not in DC. But thank you all and have a great day.